Welcome to Dad Talk Today. Dad Talk Today. The podcast for dads facing some of the toughest moments of their lives. We are here to walk with men through divorce, keep them connected to their kids, help them understand their rights, and work for change in family law courts. Moms, you are always welcome too. We are all about advocating for shared parenting and doing what is best for our kids. Here is your host, Eric Carroll.
Hey everybody, welcome back to Dad Talk Today. I'm Eric Carroll and I'm joined with Mr. Kevin Hickey. Heck, Kevin, what's going on, man?
Hey man, not a lot. Just another Monday, man. How are you doing?
I'm doing all right. We've had a lot going on. Guys, if you want to ask your questions to Kevin, please write them down in the comments and we'll get them and make sure we get this out there. This does not create a client-attorney relationship. Not meant to be professional legal advice, even though it's coming from a professional. And Kevin, you are most familiar with the law out of Arkansas, but a lot of that goes hand in hand with some of the other stuff. So, but I think, Kevin, before we get into this, one of the things we've been talking a lot about here recently is what are some of the things that you should look for when going to get an attorney?
Well, you need to meet with them personally, and what I mean by that is in person if you can. With COVID, the last several months, a lot of our initial consultations have been by phone or Zoom, and just out of necessity, and that's fine. But you get a little more of a sense. Do a Zoom call at minimum if you can't come in. You may feel comfortable doing a consult over the phone, but a lot of people want to be there personally. And so you can really get a sense of the attorney. How do you feel when you're in his office or her office? And you can really sit in the same room and talk to them and see if you have a good, comfortable fit.
How accurate are Google reviews? Do you suggest people going and reading those? I know sometimes those can be hit or miss as well.
That's a real good point. And I think they're hit and miss, but I think it can be a starting point. You can't decide it by Google reviews entirely. I mean, there's always somebody that you may have not gotten along with well as a client. They're disgruntled for whatever reason, and they put something out there, and you're not always getting the whole story when you get a negative review or something like that. So that's a good starting point. That's one of the things to look at, but not the decider.
Absolutely. We got our first question in here from Paige Ree. She said, many fathers' rights activists who push for 50-50 even when there is domestic violence against the children. What is your take when there is domestic violence against the children by the father? Do you still advocate for 50-50 in these cases? I think that's where the rebuttable presumption comes in. Nobody is advocating for anybody that's actually committing domestic violence, but there's so many allegations going on right now. What's your take on that, Kevin?
I know in Arkansas, there's a statute that mentions, and this is a different kind of rebuttable presumption from what we'll talk about in a minute. But there's a statute that talks about domestic violence, domestic assault, and it's in the child custody section. And it talks about that if a parent has been convicted of domestic assault of some kind, there's a rebuttable presumption that they are not necessarily fit for custody. So that's one thing to start with. And I'm guessing most states have that. So if that's going on in your case, you may want to check into that. But yes, that goes to the rebuttable presumption on 50-50. We talk about shared parenting a lot and that legislation. And one thing that Eric and I have talked a lot about is it's important for me to have that rebuttable presumption language in there for the situation that you're talking about, Paige, that where one parent is actually an abuser. You've got to be able to say, look, Judge, 50-50 is not going to work in this situation, and we can't have an abusive parent getting that much time.
I think that's a common misconception. Domestic violence advocates are a lot of times opposition when it comes to shared parenting, but we're on the same side. We don't want domestic violence happening either. And a lot of what's going on, these people that are making false allegations, it's became so common. It's taken away the credibility from the ones that it's actually happening from.
Well, it's the crying wolf syndrome, and everyone, I'm all about going after people that are making false allegations because it can destroy lives. But everyone that is worth their salt that does this kind of work knows that there are serious and confirmed and credible allegations out there of abuse. I mean, it happens. Abuse happens, unfortunately. So no one's saying that it doesn't.
All right. I think he might have worded this wrong, but Boynton Champ was saying, if you don't go to court, do you still get things with your kid? I think there's not really any rights if you don't go to court, is there, Kevin?
Well, yeah, it's kind of hard to tell what he's saying there. If you don't go to court, you can be found in default. Obviously, it looks very poorly on you to the judge. They take the position a lot of times that if you're not going to take the time to come to court, why should I take the time to craft some kind of visitation schedule for you? So you're really running a risk if you don't go to court.
Absolutely. Winford on YouTube said, what if both parents have restraining orders against each other? In my case, my wife was the abuser, but because of the false child abuse allegations against, which was under investigation at the time.
Well, that can happen. What I have found is a lot of times one party will file for a restraining order. The other one will then go down and try to file one. And a lot of times the prosecutor or whoever handles restraining orders won't let that second parent file it because they've caught on that they're filing them against each other. I don't really know how to answer that. I don't know what a judge is going to think about that if both sides have restraining orders against each other. I would think they're going to think that both sides may have some issues that are causing strife in the relationship.
I could see that because it's like, which side do you listen to? You know, I mean, it's
right.
I could see that. Thank you for that question. We've got a question from Oscar Briones. He said, my son is now 12 and he's been with me for 3 months. Mom hasn't made an effort to take him for her time and has just said that she's sick and can't take him, even though she has 3 other kids. Should I go back to court and fight for full custody?
Okay, this happens sometimes, and it's a really good question, where one parent, for whatever reason, will stop having the child for a period of time. And we have clients come in with a situation like this. It could be 3 months or 6 months or a year or longer, where one parent will come in and say, look, I don't have custody, but the custodial parent has kind of let me start keeping the child all the time. And we usually advise that, yes, that's the time you go back to court and explain to the judge, look, we don't know what's going on with the other parent, but I'm now kind of the de facto full custodian here, and we need to get that legally changed.
Absolutely. Got a question from Brett Downing over here on Instagram. He said, my ex's lawyer has submitted false financial statements trying to hide income. Also feels like I'm falling into a Marsha Kleinman scheme. How do I navigate that?
I don't know about the Marsha part.
I don't either. It's my first time.
There's a couple of different things there. You're talking about hiding income, then you're talking about filing false financial statements. Obviously, if they're intentionally putting false information in the financials, that's something you're going to have to flesh out through discovery and have your attorney help you show that that's false. And then your attorney will know if sanctions are necessary against the other lawyer, or if it's just something you need to bring up to court in the court hearing to show that it's bad information. The hiding income thing can be a little different. You can file financial statements or tax returns, and they look completely kosher, but then there's hiding of income sometimes. Most of the time when we hear one spouse accuse the other one of hiding income, it has to do with they're taking cash out, or they'll take their paycheck to the bank. They don't have it direct deposited, and they'll deposit half of it, keep cash out, and they're hiding it somewhere. They're hiding cash. That's the old traditional number one way of hiding income. Now, if you own your own business, people will try to hide income, purchase things through the business that are actually for personal reasons. That's another way you can hide income. So I'm not sure exactly what's going on in the question there, but need to talk to your attorney, and through discovery and through depositions, a lot of times you can kind of get to the bottom of it. And you may need to get a forensic accountant involved.
There you go. Thomas McCarthy said, are family court judges, or are they executive administrators for the state?
I'm not real sure the executive administrator. This goes back to one question we had last time. Most of family law is by state. So every state, their courts have different names. Their judges have different names. Sometimes you hear the word magistrate or chancellor or judge, and they're all the same thing. So executive administrators, I'm not really sure what that means. I can tell you that family court judges, at least in Arkansas and pretty much in all the states that I've practiced in my cases, are judges. They're attorneys that have either been elected or appointed as a judge, and they are actually full-fledged judicial members.
Gotcha. Win Ford said, another question, please. I am in New Jersey. I know the law is different state by state. I have my first motion on April 1st. False CPS allegations proved to be unfounded. How can this be used to my advantage?
Win, if you can give us a little more information on what your motion is before I answer that, maybe you can put it down there in the comments. Is it a motion for change of custody or visitation, or what is it? And then I can help you.
There you go. Francis Froley Joseph said, is judicial immunity absolute?
I'm laughing. Francis, let's talk about that at another time. I'll call you.
There you go. Matthew Ryan White said, my ex-wife claimed and made a false CPS claim. I went to court Friday. I'm in NorCal and daughter in SoCal with ex-parents. The CCI recommended Wednesday through Sunday with me in San Francisco. They had me driving North Cal to SoCal every weekend. The judge seems really biased. In addition, in California, they continue our court date 3 times. In addition, court date was 1:30 p.m. and they call me at 11:30 for court. What's your thoughts on that, Kevin?
Well, I'm trying to see what the question is. That's a lot. Northern California, Southern California are a lot. I mean, I'll probably start an argument, but I've always thought they need to be 2 different states, but they're definitely far apart. That's a long way to be driving for visitation. I guess I'd need to know more about what the actual question is.
Yeah, and we got to see that a little bit when we was over there not long ago. Everything seems to be so far apart. I can't imagine. I mean, talk about John, man, the trips he was making just to see his kids.
He was 13 hours both ways.
I have no idea how he done that, man. I know he wanted to see his kids, but Chris, I'm going to try my best to get this one. Zed Wojcicki said, let me know how I did on that. He said, how long do you wait before filing contempt for custodial interference, and how to log it properly for lawyer and the courts?
I'm going to start with the second part of that question first. You can file police reports. That's one way to keep track of it. You can get a diary. I always tell clients to get a calendar together and a little pocket calendar, or you can do it electronically and use it just for your case. So you can put on there the date that something happened. So if something happened today, you would pick today in that diary or calendar and write down what happened. That way you have a running timeline of things that have happened. And some people will do police reports and say, I just want to and most police stations are really good about just giving you a report saying, we really want to press charges. We just want to keep a record of it. The how long do you wait? There's no black and white answer to that. I have had clients the day after the divorce is final call me and say, I want to file for contempt. She didn't do blah, blah, blah today. Judges want to give you some time. There's usually been some animosity and both parties are on edge while litigation is going on. Give it a little bit of time after you've just been in court before you have to go back. It's much better to go in with a real good long track record of something that's happened to show the judge, look, judge, this was not a 1 or 2 time thing. This was a pattern with him or her of interfering with custodial rights, and you need to do something about it. So if you can wait for a while, I always suggest that, but sometimes it's so severe you got to do something.
There you go. Hey, thank you for that, Chris. And guys, if you're watching this, please make sure to like and share it, and let's make sure that this gets out there to somebody who needs it. We're going to get to our next question from Buddy Love. He said, can my soon-to-be ex-wife force a custody agreement that causes me to lose my job or lose my income?
I wouldn't think so. If it's an agreement, that means you're agreeing to it. So, and remember, on agreements, it's not the attorney's job to agree for you. It's your job, and it's your you're the person that has the authority to agree to something or not agree to something. Your attorney is there to advise you on it and answer any questions you've got. So if it's something that you feel like is going to cause issues with your job or income, or other factors or facets of your life, don't agree to it. Talk with your attorney about alternatives, and maybe you can make some kind of counteroffer.
Absolutely. So we got a good question coming up. I think I read some news that this is about to happen again. A lot of parents was talking about this last year. This one comes from Amy Johnson. She said, are the COVID-19 stimulus checks that my ex received for our daughter her property, or was this money supposed to be deposited in our daughter's savings account? Neither I or my ex were affected in terms of unemployment or lost revenue affected by the COVID-19 pandemic.
Oh my gosh. I'm gonna give you such a lawyer answer. You're not gonna like this, Amy. It depends. And part of it, I don't know. We have had more issues over COVID-19 stimulus checks than anything I can think of in the last few years anyway. People keeping checks, keeping the other party's check. People have gotten divorced, but the IRS sent the check, or the Treasury sent the check out either by direct deposit or whatever into one person's account, and the other person won't give the other person their half. Yeah, but there was a definite delineation in most checks, at least in the initial round. I'm not sure about after, that said, here's how much one person's getting, here's how much the other person's getting, and here's what you get for each child. And the children's checks, usually we were able to work something out where if they were with the custodial parent, most of the time that parent got the children's portion of the checks. If it was joint, then there was a good argument that it needed to be split. I don't think there's any hard and fast rule on that. I think different courts are handling it differently because there's really no guidelines on that for when there's a separation or a divorce or a child support situation.
I know a popular topic was a lot of the dads was reaching out saying that if they was in arrears, they took their stimulus checks from them as well.
They sure did. And in Arkansas, it's called the Office of Child Support Enforcement, and they're a government agency. So they have a lot of tricks or tools they can use that private attorneys like myself can't use. They can take if it gets serious enough, they can take your driver's license. They will take your tax refund every year. And that includes if you've gotten remarried and your new spouse was supposed to get some money back, they'll seize the whole thing. So yeah, that can definitely happen.
That's one I've never understood. If you take the guy's license, he's got no way to work.
Yes, that's an argument we have to make. Yeah, you're making it even less likely that they're going to get any child support.
Yep. Hey, thank you for that question, Amy. We got one from Jenny too. She says, what happens when mom lies on her financial statement several times, but when we did a discovery for her bank statements, it shows she makes way more than she claimed. She claimed $30,000 and the bank showed $64,000. Will the judge see through this?
Yes, if you show it to the judge. Something like that is that big of a difference, you want to make sure your attorney either will put together a graph or will really set it out through testimony that what has happened. But you will need to show the financial statement and put that into evidence, and then take the bank statements and put that into evidence. And you can even use it on cross-examination with mom to show that she didn't claim everything. And that's something like that I usually like to save for trial, so they don't have an opportunity. If they know it's coming, they'll try to get an answer or story together in their head to explain it. But if you can kind of catch them with it at trial, they're kind of caught off guard.
Hey, thank you for that question, Jenny. A lot of these people we're seeing are first-time viewers. I want to say thank you for tuning into Dad Talk. Again, guys, please like, share, and tell people about this program. We want to make sure we've got it going for people that need it. Marianne Petrie said, what do you do with a judge that refuses to recuse himself, yet an appeal would take too long?
Well, I don't know that there's a lot you can do about that. And every state is different how they handle recusals of judges. A lot of times you file it directly with the judge that is hearing your case, and they make a determination if they need to recuse or not. Some states have a procedure where you file with a different judge in that county or district and have them to review it and see if they need to recuse. And then in other states, you go straight to the Court of Appeals and try to get it done that way. So if you had to file with that judge, it sounds like you requested that judge directly to recuse. And if they don't, I think it is an appealable order in most states, but of course that takes time. So the answer is you're probably stuck with that judge.
There you go. Thank you, Marianne. Steve Krug said, what's your take on passing laws that raise the bar in favor of using strict scrutiny when revoking or altering custody between parents?
Strict scrutiny, that's a little bit of a constitutional law phrase there. I think he may be saying a really higher burden of proof for revoking or changing custody. Most states have a variation of what we call a substantial change in circumstances before you can change custody. Different states have a little different phrasing, but it kind of means the same thing. And it's pretty high burden. You've got to show that things have really deteriorated or gotten worse for the child or the children in the environment they're in, and that custody needs to be changed in order to get them a better environment. So I don't know if you're talking about a higher burden of proof there. I think you are, but it's a pretty high burden as it is.
There you go. Hey, thanks for that, Steve. We got another Steven in here. Stephen Cobb said, my ex-wife married a militant lesbian. Nothing against homosexuals in general. And she posts very extreme messages about hate of men, no need for fathers. Men are just donors.
Yeah.
Can I use that in court?
Yes. And you may want to get an expert involved to talk about how that can affect a child or children that are in that home. Yes, that's something that you will want to bring up. Having their own view. Judges are very, very hesitant to try to get into actual parenting of children. They want to try to leave that constitutional right to the parents to choose how to parent their children. But what they are also charged with is making sure they watch and take care of the best interests of the children and the well-being and welfare of the children. And if they feel like one parent's views are starting to cause some kind of emotional harm or other harm to the child, then that may be a time that they need to step in.
There you go. Hey, thanks for that, Stephen. Ryan Hunt said, how about a $916 increase over a $493 a month order to the tune of $1,409 a month, plus a year's of back pay of retroactive from when motion was filed? Ex-wife paid flat fee $6,000 to her attorney, who is best friends with the judge, to get this done. Paid into system since 2009 without a missed payment or a late payment. Ooh. What's your thoughts on that one, Kevin?
Well, child support is usually, every state, again, is different on how they calculate child support. A lot of states have child support charts, or they will compare the custodial and non-custodial parents' incomes and come up with child support, and some do a combination of both. I don't know. I don't know what happened in your hearing. I would have to guess that a lot of it was based on your income. Paying the flat fee to an attorney that's best friends with the judge. Well, I don't know. I don't know if you're trying to say that somehow influenced the judge or what, but it's hard to say. Hard to say.
Gotcha. Heather Moore said, I love Dad Talk. Heather, we love you. Thank you for watching our programming. Jacob Niner said, what if they owe student loans and child support? Will the payment go to student loans instead of paying off the back payments on child support? That's a new question. I haven't heard that one.
Well, What payment? I'm wondering. Is it talking about if a tax refund is seized or something, or
what if they go student loan? I wonder I think he's probably talking about the stimulus checks. I don't know, Jacob. I tell you what, man, follow that up and just kind of clarify it for us. We want to get to your question, I promise you, but can't quite make out what we're going with here. So I'm going to go to the next question. We'll get back to you, I promise. Jacob Mateer said, how do judges view a mother that doesn't follow 50-50 legal custody? Provisionally, I have 50-50 legal and was told I'm not allowed at his 3-year-old doctor checkup due to COVID. I spoke to doctor prior to the appointment and I was allowed in. When she saw me there, she flipped out when she saw me. She also has speech therapy appointments for our son that I haven't been given location or dates of.
Well, you're talking about, and I don't know on what level of the scale it would be, 0 to 10, but you're talking about some alienation there. Those are things that a parent engaging in alienation would do. They try to keep you from doctor's appointments. You have 50-50 legal custody, which in most jurisdictions means you've got just as much equal decision-making authority with mom as she does. So you're able to make those decisions together, including doctor's appointments and going to doctor's appointments. You're supposed to be allowed to go. You're supposed to be informed in those decisions. And if mom's not doing that, then she is, at least on a minor level, alienating you out of that decision and even going to that appointment. I will tell you, we got some complaints when COVID started, and still do, where one parent will complain about not being able to go to the doctor appointment. And it turns out, and you need to check on this too, some doctors' offices and clinics will only allow one parent in for an appointment. So sometimes it may not be I'm not saying this is Jacob's case, but sometimes it's the clinic saying only one parent can come in. You have to look at that too.
Yep. Thank you for that, Jacob. Jason Hendricks said the government is getting ready to pass a $300 per month child credit paid out per month. If the mother has the kids and I am paying child support, will that extra $300 per month, $1,200 per month for my wife, be offset in child support payments, or will she get that plus my child support?
I am not certain on that, but you will want to talk to an attorney in your jurisdiction. $300 per month child credit paid out per month. That it's worth checking into. You might be able to file for some kind of reduction and argue that mom's going to be able to continue to get the same amount of support each month now that she's getting that payment. But you'll just have to check on that.
Yeah, and Jason, I know you said right here the government's getting ready to pass that, so we might not know what that looks like until it's done.
Yeah, and it may only last 2 months, 3 months, who knows?
But stick around with us, bud. We will find out. Brian Stark said the gal on our case did not stick with the agreed payment contract to her for her services. Is this legal, and would I have legs in court?
And for those of you that don't know, GAL, G-A-L, that's guardian ad litem, that is usually appointed to represent the children in the case. And usually what happens is the fees of the guardian ad litem are split, unless the judge sometimes can decide not to do it that way. But usually each parent will pay half of that fee. So I think what Brian's saying is that he had a contract with her for her services and didn't stick with the agreed, I guess, payment plan. If it's a contract and you both signed it, it's a contract. Yeah, it's legal. And if you think she or he has violated the contract, you can do something about it. Usually the first step is either, if you have an attorney, have your attorney contact the GAL and talk to them about it and get it worked out, or you can do it directly if you want, if you don't have an attorney. But I would start with that and try to work it out before you went to court.
Hey, thanks for that, Brian. We got a question from Nolan Thorsrud. He said, I have had the same judge all 5 times. My ex has falsely accused me. How do we move the case for appealing the decree, but make sure we get a different judge? This is going on over 3 years.
I don't know that you're going to be able to get a different judge. Most jurisdictions Even when you go up on appeal and it comes back down, we'll put it back with the same judge. There's the thought there that they want a judge that has been familiar with this case for a long time and is up to speed on all the parties and the evidence from before. And the thought on that is that makes it better for all the parties to kind of cut to the chase as to what's going on this new time that you're in court. If you've had that many situations where you've been able to show that these accusations are false, you've got to start highlighting that if you haven't already, or your attorney hasn't already, to the judge. I mean, most judges get tired of that pretty quickly.
There you go. Tracy Palma said, why do judges impute income? Fathers prove what they make a month, and the courts ignore that proof, and they charge them with more than they make per month. It makes 0 sense.
Most judges have that authority, that if they think a father or mother, is whoever the paying parent is working below their capacity, they've taken a job for less money to try to avoid paying child support. Or if they're not working at all, most judges will impute income and say, well, we think you can at least find a minimum wage job, so we're going to impute that amount of income to you. But the judges have that authority. If you're facing that kind of an allegation, you've just got to show that the job you have and the money that you're making is reasonable, and it's what you're able to get. It's the job you were able to get and the income you're able to get, and that it's not through any fault of your own.
Yeah, that's kind of interesting. I know this one father in Atlanta, Kevin. He makes $225,000 a year, and after he gets home with his paycheck every week, he brings home $25 on his paycheck. This guy was just about to go nuts, and he showed him numerous times what his income is, and they still keep charging him. And we had Dr. Carlos from New York. They charge him $16,000 a month. He got $600,000 behind in child support, and this is a doctor, and they lock him up.
Wow. Yeah, it can get out of hand in a hurry, and it's just something that you've got to show judges what your true income is. And especially if you're self-employed or if you have a really high income, your tax returns can start to get a little convoluted. And sometimes you have to walk them through what your actual income is. And sometimes it's very, very helpful to bring your accountant in, because your accountant can explain it better to the judge than you can. But you've really just got to try to show them what your true income is, and so they'll get it more accurate.
Gotcha. Troy Sarr said, doesn't our U.S. Constitution protect us under a Chapter 236, the nuclear option, being found guilty of domestic abuse without any evidence?
I am going to feign ignorance on that one. I do not know what Chapter 236 is. So I don't know, Tony or Troy. Sorry about that.
Well, Troy, I'm going to tell you something, and I don't either. So I'll figure it out, and we'll get back with you. Jacob Matera said, I love Dad Talk. Sitting in the hot tub, Max relax. Thank you, brothers. Hey, that sounds like a good place to be. You know, one of the most common things I hear of, Kevin, I didn't realize how common false allegations were inside of the family court. If I was a father and I just had an allegation made against me for the first time, what would you say I should do in preparation of that?
Well, you've got to talk to an attorney first, because when a false allegation comes up, 2 or 3 or even more things can start to happen. A criminal case could develop out of that. A CPS case could develop out of that. In Arkansas, we have what we call the child maltreatment list, which is a list for people that have abused or harmed children in some way, and that can affect your employment. Most states have that list. It can be called different things in different states. All of those things can be triggered when there's false allegations against you. So you need to talk to an attorney as soon as you can and get a game plan together of, are you going to talk to the investigator or not? Who's making the allegation? Has a custody case just been opened? If it has, your attorney needs to make sure that investigator knows that, because the research across the country is clear that the vast majority of false allegations come out of custody cases, and that's where they get initiated. So you've got to make that investigator aware. And so talk to an attorney first and start getting a game plan.
I know perjury is against the law, but how often do you see someone, if you can prove that they made a false allegation, what type of consequences do you think they're facing, and do you think they're severe enough?
No, and usually as far as consequences of prosecution or something like that, nothing ever comes of it. What to me is more important, because I hear that all the time. Client says he committed perjury. I need to do whatever. We use it in court. You need to show that judge that this person cannot be trusted and that their credibility has really been damaged by all of the lies they've told. It reflects on their character, and you want to make sure, because most judges that do family law in most jurisdictions, a lot of times in some places, that's the only kind of cases they have. So they see this over and over. So if you can start to show that pattern, they get it. That if mom or dad is on the stand lying constantly, they're probably doing it at home too. And that is one part of a very poor environment for the child. So you've just got to really point it out.
Absolutely. Jacob reclarified down here. He said, what if they owe student loans? Would you still get the back child payment when taxes came in?
I would think so. I'm still a little unclear. I'm wondering if he's saying if there's a child support arrearage, or if they had a retroactive child support that comes in, and I don't know.
I think you might be getting at, the student loans mixed in with the child support, and child support arrears. They'll take that out of your income taxes. I'm not so sure about student loans.
Student loan unless you have a judge. Now, I wonder if he means that there's a judgment for non-payment of student loans, and then a back child support arrearage judgment. Which one's taken first? Usually they take the child support first, but I don't know.
I got a question for you, Kevin. Now, what if somebody has gotten custody of their child, but child support keeps taking out, and they've been notified several times, hey, I now have custody of the child, but they keep doing it?
Like when custody's been changed, maybe?
Yep.
Yeah, we try to put it in the order that child support is abated immediately, or the judges will usually put it in there that's to stop immediately. But sometimes, especially if there's an automatic withdrawal, direct deposit, it takes some lag time there. That money is supposed to be returned. And usually we can work something out with the other side and say, look, she got 3 more payments before this switched. Can we get that back? But if you can't get it worked out, you just have to go to court, because equitably you should get that money back.
Well, that's happening to me. That's why I was asking. Yeah. I mean, it's one of those things. Yeah. I've been going on with it. What are some of the common misconceptions that, you get in a divorce, it's going to be highly contentious because you're in an argument with your ex and you no longer want to be together. What are some of the worst mistakes that people make out of that anger when getting into family law and trying to get custody of the children and making their way inside the courts?
Texting it, emailing it, because what are you doing? You're creating a forever record of what you just called your ex or what you said, putting it on social media. All of those things these days are things we didn't have to deal with even 15, 20 years ago. You've got to be careful what you say and how you say it. Saying something back in anger or going tit for tat. I mean, when a case is starting, you have to assume that everything you text or everything you email or everything you say on the phone or any other time is either being recorded or kept or whatever. And I tell clients, just imagine that text you just sent being up on the big screen at trial and the judge reading it. How would you feel about it? So don't do it.
Absolutely. Merged Music and Film on YouTube said, how can we assist the court to realize the allegations are false?
Well, that can be a very complicated answer. You have to, again, see if there's a custody case going on. What was the nature of the allegation? If we're talking about a child, was it actually an allegation? Some people will see the forensic interview of the child and look at the transcript and start reading it. And when you really read it through, there wasn't really an outcry or an allegation. Somebody that read that, such as a caseworker, and then wrote their notes out, said that there was an allegation. But when you really look at what the child said, there wasn't. And remember that too, when you see a caseworker's report of a child's interview, that's a caseworker's report. That may not be exactly what was said. That is someone's opinion of what they heard that child say, or what they think they heard that child say. So when you're looking at notes, that's what you're looking at. Did the child tell more than one person? Did the story say the same? Have they done this before and over and over and over? And every time it was proven that the child was unreliable, or that mom or dad was coaching the child. Those are all things you've got to look at when you're dealing with false allegations.
Yeah. And so Jacob re-clarified, he said they owe student loans, which the IRS takes from her taxes to pay it off. If she has not paid any child support when taxes come, would they use her taxes to pay the loans, or what is owed in child support?
You're getting into what we call, and I can't remember, I don't do a lot of this, it's hierarchy of debts, judgments, which would be paid first. Normally, child support trumps pretty much everything. But when you're dealing with a student loan, that's probably from a government agency like a Fannie Mae or something like that. Sometimes they are put at the top of the list. So, Jacob, I now understand what you're asking, but I don't know the answer to that. To me, and if I'm your lawyer, I'm going to be arguing to the judge that the child support should be taken out first. But that may just be determined by the IRS regulations. I don't know.
You know, they say that's one of the hardest things to get rid of is student loans.
It is. It is. You can't bankrupt them. Now, there's been some legislation put forward to try to get it to where you can bankrupt some of those if you have to file bankruptcy, but I don't think that's changed anything yet.
Trade schools, people. I think we don't push those enough for our kids, but anyway, that's a different topic. Hey, appreciate you for clarifying that, Jacob. Amy Johnson said, my ex keeps telling false statements about me to our daughter. She is telling our daughter that I picked my job over our daughter, which is not true at all. The parenting agreement says we should not talk about what happened with the divorce, but if I do not talk to our daughter about what happened, she may spend the next 8 years being fed lies. May be too late. Does the parenting plan really have any bite when it comes to court, since my ex tends to violate it all the time?
It's what you can prove, and you've got to be able to prove what's being said. And many times, unfortunately, that requires the child coming in and saying, and testifying and saying, yes, you know, mom or dad tells me this all the time or that all the time. I know it's not right or whatever. Or they can tell the ad litem that, and then maybe the ad litem can share it with the court. But that's one of the primary things you've got to do, because it's not supposed to be happening. You're not supposed to be talking to the child, and it puts the other parent, which is where you are, in a very tough spot, because you know you want to be able to talk to the child about it. And I have always told clients, as long as you're truthful with them and use discretion about what you talk about, then you can talk to them about it. Usually what the court orders say is don't talk about the case. So don't be going in there talking about what's been filed, what the last order said, what was done in court. You're not supposed to be talking about those kinds of things. But many times it is okay to talk about, if your ex brought up a situation that you feel like you need to clarify, many times it's okay to do that. Now you need to read your order, and you need to talk to your attorney about what your order says to make sure that's okay, because every order on that is different.
I know that's kind of a rough one, you know, because you got the kids, they'll come up to you and say, well, mom or dad told me this, and there's another side of that story. And it's like, do I let it sit? I think then they're wondering, am I crossing the lines of alienation? But
I don't think it's very fair when you're presented with something like that to not be able to say your side of what happened.
That's right.
But unfortunately, it ends up, you know, if you're going to go into a 30-minute in-depth spiel of what happened with an 8-year-old, I mean, that's going to cause a lot of problems. So sometimes you can say, well, that's not really what happened or whatever. I mean, it's a slippery slope. It's hard to deal with.
Yep. Anthony Conti said, if the rules, laws, and statute that govern our society are written for everyone to see, why is prosecutorial discretion existent if we expect everyone to follow them?
I'm not understanding that one. I don't think I'm understanding that question.
Yeah, Anthony, get that back to us, man, and I'll make sure to pull it back up. Amber Leanne Flores said, can the Office of Child Support Enforcement in Arkansas increase amounts of child support without notice? I already agreed to an amount that also includes arrears, but they upped my amount by $44 a week without notice.
Agreed to an amount that also includes arrears. I would think, Amber, since you're in Arkansas, what they will do many times is add what's called a percentage. They'll add 20% or so to whatever you're supposed to pay, and that additional 20% each pay period goes to your arrearage. They won't sometimes put that exact amount in the order. So a lot of people see their child support amount there and think that's what they're going to pay, and then they get the withdrawal out of their paycheck, and it's a little bit more than that. Well, it's because of that arrearage. So you may want to double check that and see. And as far as giving you notice that that's going to happen, what they would say is it's in the order. We just didn't spell it out that way. It just says an extra 20% is going to go towards your arrearage. That may be what's happening there. But to answer the first part of that, no, usually they have to give you notice if they're going to change your child support, because then you have an opportunity to come in and argue your side if you think it needs to be different.
All right, so Anthony re-clarified. I'm going to read the first one with this one, and let's see if this makes a little bit more sense for you. He said, if the rules, laws, and statute that govern our society are written for everyone to see, why is prosecutorial discretion existent if we expect everyone to follow them? And if we expect everyone to follow them, why do judges, some lawyers, and arms of agencies of a state able to get away with violating them with no repercussion?
Can you put that first part up again, Eric?
Yep.
Rules, laws, statutes, and govern our society. Okay, I think what he's saying is it should be black and white. If we've got statutes and laws and everything, it should be black and white whether someone's going to get prosecuted or not. So why do we even have prosecutorial discretion? Why does that even exist? Well, because sometimes they decide not to prosecute for some reason or another. They either don't have enough evidence, or the case is not as strong as they thought it was, or they've investigated a little bit further and there may have been a crime committed by the alleged victim. They want to have prosecutors to have that discretion to not bring certain charges in certain situations.
Absolutely. Troy Saar said, in Iowa, my ex filed a Chapter 236, a domestic abuse claim. No evidence, no police report, no prior cases, yet judge orders me out of the house. I have 20 minutes to grab my things. Doesn't the Constitution say innocent till proven guilty? So how can this happen? Why has this not been tried at the Supreme Court?
Yes, Constitution says it's a tenet of law that you're innocent until proven guilty, but many times in situations like this, it's the reverse, especially when there's false abuse allegations. You feel like it's guilty until you're able to prove your innocence. Domestic abuse claims fall into that situation, and many times prosecutors, police, all go with one side until they see something different. And many times they only give you so much time to get your things out of the house. You just need to get an attorney. You need to sit down and you need to get a game plan for how you're going to prove that this didn't happen. That's about all you can do.
Yep. Jacob Mateer said, speaking earlier about alienation of level 0 to 10 with my doctor's appointments, my 3-year-old son says yes to loving his mom, grandma, grandpa, cousins, Scarlet, dog at dad's house, but always says he doesn't love dad every darn time. It hits me hard every time. Would a 3-year-old really say that, or is someone telling him that? I know my son loves me other than what he says due to our relationship and the fun we always have together. I mean, I guess that's kind of hard to know without knowing the details and everything that surrounds it. I think sometimes alienation can happen just from not being with the parent, but in a certain amount of time. But he brings up something I'd like you to explain to the guests, Kevin. Alienation has different levels. We have mild, moderate, and severe. Could you explain those different levels for the viewers?
Yeah, and I guess you can give a little bit of examples, but the lower levels usually deal with maybe an eye roll here and there when the other parent's name is brought up, or they talk loudly on the phone with their friend and to where the child can hear, and they'll say something a little bit negative about the other parent. And then it can start to move to refusing visitation once or twice or here and there, not allowing you to go to doctor's appointments, that kind of thing. And then it can get to the point where it's just refusing outright any time with the child. Poisoning the well with the child is what I call it, coaching, false allegations. It can get really, really severe. So those are kind of the different levels. Can you put his question back up again? Because there was something I wanted to address on that. Okay. So the real question is, would a 3-year-old really say that, or is someone telling him that? I don't know. Based on the other things you're telling me, he may be hearing that or heard it once. Maybe he's wanting attention and saying that. It's hard to say. When you're dealing with a 3-year-old, their minds change every 30 minutes on things. But on alienation, one of the things I've been seeing recently in some of the research, and I think that we're going to start focusing more on, is when you're showing that after there's been a separation of some kind, then all these allegations start coming up, or the child starts pushing away the other parent, or like in Jacob's situation, saying doesn't love the other parent or something like that. We really have to focus on the relationship before there was a separation. If the parents were together for a significant amount of time, if the child was well adjusted to dad in that situation and totally interacted with him fine, why all of a sudden when there's a separation, now there can be a little bit of separation anxiety there, sure, in any case, but why all of a sudden is that directed negatively at dad? You have to wonder. You can't say it's going on for sure, at least at that early stage, but you have to wonder what's going on in mom's home, and are negative things being said that's causing this child to feel that way. I'll tell you, it's very hard when you're dealing with a 3-year-old because their language is not developed. They use the wrong words, and they're just young. They're just young kids, and it's kind of hard to discern what's going on sometimes.
There we go. Corey said, how can we all work together to help make real change?
Real change well, let me tell you, if we only had someone to go to Michigan and all these other places and talk to legislators and stuff like that, someone that really was passionate and really wanted to be involved. You know anybody like that, Eric?
Yeah, a little bit. I tell you guys, I think coming off of last week, we've got more eyeballs on these issues than we ever have. It's usually not an issue that people touch on, and we need to get everybody involved. And when we're doing these shows, everybody needs to show up. You need to you need to share it. You need to be going to your local GOP and DNC, your Democrat chambers, making relationships, passing out cards, talking to them, telling them what you're going through. Every little thing helps move the needle in the right direction. And it's little things like that get overlooked. Everybody just wants it to happen overnight. This has been going on for decades. It's not something that's going to go away overnight. And we've got to organize and come together for this to take off. And I believe it can happen. If I didn't believe it could happen, we wouldn't be here doing this right now. So, yep. Had another, and I appreciate you for asking that, Corey. I really do, because I believe we got to get everybody involved, man. I think a lot of these parents, Kevin, have been in this community for so long. Some of these parents have been alienated 10, 20 years, and I don't know, they've done, their kids have been aged out of the system, but they're still here fighting for change because they don't want anybody else to go through it.
It's hard because you're moving a mountain is what you're doing, and it just doesn't happen overnight, and it's hard. It just takes time, and you have to get more and more momentum and keep chipping away at it and working at it.
It's getting momentum, guys. We've got the politicians, we've got actors, we've got everybody talking about it that we've been begging for a long time. So now is the time to get active. If there was ever a time it was going to happen, it's going to be right now. So thank you for being here, everybody that's here, and it does make a difference. Hani Katab said, does it make a difference who started the divorce about child custody and alimony?
Not necessarily. It depends on the factors as to why the divorce was started. She might be asking who files first. One of the main advantages for filing first is usually you get to present your evidence first at the hearing. So if there is going to be some kind of custody issue, and I want to make sure it's important we get our narrative out first, I do want to try to make sure we get filed first. But a lot of time, both sides get their opportunity to present their case. So a lot of times I don't know that it makes a huge difference.
Yeah. Ryan Hunt said, what is Kevin's point of view on the standard possession order?
I don't know what that is. And that may be where he lives with that. What does the standard possession order mean? Is that a custody visitation schedule?
I think so. I think it could be like weekends or the every other weekend normal scenario that a lot of these guys get.
Well, and maybe he's asking, do you think it's okay to have a standard one? I mean, I do, because I think it's a good starting point. But early on in your case, if you want something different than that, start negotiating for that. Start preparing your case for that. Most judges are going to listen to what you want, and if it works for the children and the other parent and you, they'll probably try to implement it. If both parents are good parents and there's nothing against you, put the schedule out there that you want and show why it works and why it'll be good for the kids.
There you go.
That's just a starting point, the standard order.
Nikki Ward said, when the judge will talk to the kids, does he do that on separate occasions? My stepkids are afraid of the other parent hearing what they want to tell the judge.
Okay, I think what they're asking is not being in the. Will the judge do that separately? They used to have what they call in-camera hearings, where they would take the child into the judge's chambers and no one would be in there, maybe a court reporter, and that would be it. I have not seen that in years and years and years. What we do now is try to get an agreement between the parents that when a child testifies, they will wait out in the hallway. And so the only people in the courtroom will be the attorneys, the child, court reporter, and the judge. That way the child's not testifying in front of the parents and can feel a little more free to testify truthfully. Now, understand, and this is at least in Arkansas, and I'm sure it's in most jurisdictions, you have a constitutional right to confront your witnesses to see what they have to say. So unless both parents agree to sit outside, then you can probably stay in there. So if the other parent won't agree to stay out in the hallway, then you're probably going to have that parent in the room with you when they testify.
Gotcha. Ryan Hunt texted down there, Texas is first, third, and fifth weekend. I looked it up too. So that standard possession order, that's a Texas thing. And it's every other weekend that the father gets, and it's assumed best interest of the child up until 3 years old.
That is a schedule that was started by a lot of jurisdictions around the country a long time ago. And the theory was, and you hear this, well, I'm an every other weekend dad. Well, they tried to make up for it by giving you several weeks in the summer, so that when you look at the time, it's still not equal, but they try to make up a lot of that time in the summertime so that you get a lot of those days and try to almost equalize it. But, it's every other weekend during the fall and the spring. And obviously moving closer and more toward a shared parenting thing is certainly going to give both sides more time.
All right. Merge Music and Film said, Kevin, you're a unique lawyer understanding alienating behavior, narcissism, gaslighting, etc. Why do most lawyers seem unaware, and how do you get the stink off of you when you get home? Must be hard. That's a good one, man. I tell you, even doing this, I'm not a lawyer, but hearing these stories all day long, it does a number on you.
Yeah. Lawyers are people too, man. Why do most lawyers seem unaware? First of all, a lot of lawyers, I would probably say most lawyers don't like to get into family law a lot because it's so emotional. It's hard. It's a grind because you're dealing with people's emotions and tough issues. And so a lot of lawyers don't even like to get involved in it. But, this kind of behavior I don't know that most lawyers that do family law and do it a lot are unaware of it. It's just we called it different things for so many years. I mean, alienating behavior, narcissism, there were just different phrases that were used for what the other parent was doing. And I still stand by it. You hear parental alienation, you hear parental alienation syndrome, you hear these words. I don't care what it's called as long as you can get those behaviors across to the judge and judge, these behaviors are harming this child. And so you've just got to show that. So I think most lawyers that I deal with in family law can see those things and try to put that evidence out there. But you've really got to hammer it home. Sometimes bring an expert in to really educate the judge on what exactly is going on in the dynamic of this family.
Right. Well, I'll play devil's advocate there for a second because I know you probably hang around some smart people, Kevin, and that's what I would do as well. But I've talked to some of these lawyers that look at me and I'll talk to them about parental alienation. And they're like, what is that? I've never heard of it.
If you just, they may not, but they know the behavior. If you start saying, well, let me tell you, my ex is doing X, Y, and Z. Oh yeah, I see that all the time. But if you don't, and you need to know those phrases, don't get me wrong, because you need to know the research and you need to know the background and you need to know the psychology, because you're going to have to bring all of that into your case, because the judge sits up there and isn't trying to decide necessarily which is the best parent. They got to decide what's in the best interest of the child. And you can talk about how this other parent is acting, but if you can't show how it's impacting the relationship that this child's having with the parents, you're going to have a problem. You got to connect that, because that judge is thinking best interest of the child, and they've got to see how that's being affected.
I've had judges that have told me they didn't know what parental alienation was and that they've never seen it before. I had one that had sat on the bench over 20 years, and he was like, I can honestly say I've never seen a case of parental alienation. And he knew what it was. And I was like, I just don't believe that.
Well, let me tell you, I've had cases where the words parental alienation never came up, but all of the behaviors were alienation, and you just laid it all out. And it was clear by the end that, oh my gosh, this parent does not need to have custody of these children. So, it's hard for me to believe this day and age that judges that do a lot of divorces and custody cases have not at least heard that phrase, because it's gotten so much more popular over the last several years.
Right.
But you never know.
Got it. Let me see. I'm going to try his name one more time. Chris Zed
Wojewski.
There we go.
Probably a Steelers fan. I bet he's a Pittsburgh guy or Philadelphia.
He said, my son, he's got to be from up north, because he said, Mom, my son's mom admitted she has cancer immediately after custody trial. How does that change in health situation for parents, such as diagnosis affect custody?
Parents diagnosis affect custody. It can. There's about 15, and I'm not going to name them all, but there's a whole bunch of factors that a judge is thinking about in their mind when they're listening to evidence in a case and trying to decide custody. And the health situation for a parent, their physical ability to take care of the children, is one factor that they've got to consider. So unfortunately, if she does have cancer and that's going to affect her ability to take care of the children, that may need to be something that needs to be reviewed and looked at again. And I'm sorry, Chris, if you're not a Steelers fan, maybe a Vikings fan or something like that. Oh, Skull, he's probably up north.
Gotcha. All right. So this is going to be our last question for the night, guys. And thank you for tuning in. We'll be back on Monday, and Kevin will be back in 2 weeks. We're going to try to be doing this every Monday for you guys. So thank you for tuning in. This last question comes from Jeswin Collins. He said, how can an ex allow you in their house after abuse claims in which they absconded with your child? I was visiting and taking care of the duties of our child for a week plus at a time. Now they are limiting my contact to 3 hours a day on visits, and then limited to 4 minutes FaceTime a week now.
I'm a little confused on the facts there. I mean, is Jeswin the one that's being accused of abuse? Because it sounds like he got limited time because of it.
It looks like he was allowed back in the house. He was visiting and taking care of the duties for the child for a week plus at a time. Okay, so he was allowed back in the house after he had allegations made against him of abuse, taking care of the child. Now he's limited to 3 hours a day and 4 minutes of FaceTime a week.
It sounds like they felt like something happened, that he did something, and they're okay with him coming back in the house, but they're limiting his time and may start increasing his time as time goes on. I don't know. Maybe that's what he's talking about. But,
Yeah.
It says his ex absconded with the child. You're just going to have to bring all that out in court and explain it and show that and show that. I mean, I don't understand. I'm just having a little trouble with what exactly happened.
Yeah. So Chris, he responded to the Steelers comment, and he said he's a Lions fan. Wojcicki. We got it now.
Okay. All right. NFC North. That's cool.
All right. So Kevin, tell everybody where they can find you if they want to get your services.
You can call us at 479-434-2414. We have 2 offices, one in Fort Smith, Arkansas, and one in Northwest Arkansas in Rogers. You can also go to the website, www.kevinhickeylaw.com. Those are the best ways to find us. And find me here every other Monday.
There you go, guys. We'll be back 2 weeks from now. And I think for anybody that hears that you practice in Arkansas, there is a law called Pro Havice where you can go in and work with a local lawyer. That's right.
I handle cases as far as parental alienation, high conflict custody cases, false sexual abuse allegations. We handle those cases all over the country. So if you have a case in your jurisdiction, you want us to come in and work with your attorney, either as lead counsel or consulting or co-counsel, however you want, we can do that.
All right. Well, guys, join us tomorrow night at 8:00. We will be live with Robert Santos. He's running for Congress in Ohio and wants to talk to you about how to get shared parenting passed in that state. And then we'll be live on Wednesday with the Mast family. You got any updates about the John Mast case, Kevin?
Not at this time, but we may have something. We may have something soon, but not at this time.
All right, guys, we will get that out to you as soon as we can. Kevin, I appreciate your time, man, and coming on here and answering everybody's questions.
Thank you so much. Now, the masks are going to be on Wednesday, right?
Wednesday, yep.
Okay. All right. I'll try to be here.
All right, guys. We'll see you then.
All right.
Thank you for joining us tonight. We are fighting for the rights of parents worldwide. If you want to help support our podcast and for us to continue this mission, please join us at patreon.com/DadTalkToday. You will find us on Facebook, YouTube, Instagram, Twitter, CloutHub, Parler, iHeartRadio, Stitcher, Spotify, the podcast app, Google, Apple Podcasts. We're a little bit of everywhere. And guys, every time you like and subscribe, you help us continue this mission. Thank you, and we will